I often imagine traveling back in time to interview Americans about a variety of issues. The closest we can get to understanding just how much culture can change in the span of a few generations is to peruse old newspaper headlines or maybe glean insights into social attitudes from commercial advertisements. If you need a good laugh, I highly recommend you look up mid-century tire commercials. The plot tends to center around a woman's inability to drive in adverse weather conditions or change a flat. Another way to take stock of an evolving culture is to thumb through the annals of our country's legal system. There you'll find hundreds of thousands of state and federal judicial opinions about what Americans were up to and arrested for, and how these defendants employed a variety of arguments to avoid conviction or overturn their sentences. Luckily, we don't have to invest our own personal time into this endeavor. Someone's already done it for us, at least as it pertains to drugs and the Constitution. In his new book, Professor David Pozen tells the story of how our legal system failed to end or sharply restrict drug prohibitionist policies using constitutional doctrine. He even puts forth some constitutional arguments that could be revived to support a personal right to drug use. But the most radical and depressing aspect of this book is how Pozen juxtaposes the social movement against drug prohibition with other social movements that invoked the Constitution and prevailed in the court system. Where the Constitution upheld individual rights in one instance, it fell short of doing so when it came to drugs. After reading Pozen's book and considering the devastating legacy of the war on drugs, I can't help but think it didn't have to be this way.
From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller.
Today, we sit down with professor and author David Pozen to discuss his new book, The Constitution of the War on Drugs.
If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series.
This is going to be a very interesting episode because typically we don't have, source material from which we are basing all of our questions, but we've been lucky to have this wonderful manuscript land in our lap to read and ingest and think about. And now we have the author here to discuss this book. And with that, I'm just going to pass it off to Doug to introduce our guest for this episode.
Thank you, Hannah. And thank you to our guest, David Pozen, who's joining us largely from the fortuity of my being lucky enough to be on his email list when he was discussing the fact that he had this exciting new book. I'll let him describe the title and some of its content in a minute, but let me just for the audience, describe who Professor David Pozen is. He is the Charles Keller Beekman Professor of Law at Columbia Law School, and he has an illustrious career clerking for a variety of prominent folks, then working in the State Department, and has had an extraordinary practice career before becoming a full-time academic, and in that role has written multiple books. And among the reasons I was so pleased and excited to have a chance to look at his manuscript was I didn't know he was working in the drug policy field because he's a constitutional law scholar by both training and inclination. But with that, Hannah, why don't you take over and we can start talking about some of the substance that certainly should have any Drugs on the Docket fan thrilled to know about this new opportunity to engage with these intersecting issues.
David, you're not a criminal law guy. You're not a drug law guy. You're a constitutional law guy or a con law guy. And yet you've written a book called The Constitution of the War on Drugs that is the intersection of con law and drug prohibition. What compelled you to tell this story?
Well, thanks so much, Hannah and Doug, for having me on to talk about the book. I could tell the origin story a few ways, but maybe the simplest way to put it is that I was struck by an absence. That is, we live in a culture where we've constitutionalized almost every social issue, much more so than other countries. We live in a culture that's known for its constitution worship, where we're constantly making moral appeals in constitutional terms. And yet here we have this major social justice reform movement underway to reform our drug laws that sounds in themes like individual liberty, racial justice, and good government. and yet no one is invoking the Constitution. So that was the absence that drew me in. Why is no one making constitutional claims for anything like drug rights when they're talking about liberty, equality, and good government? And I wanted to know where the Constitution went. Why is the Constitution on the sidelines of this major social justice movement underway?
I would say that everyone who is just a regular Joe, who's not a legal expert or a con law expert for sure, we have this idea of the Constitution. We understand that it's an important document and that it frames a lot of arguments when it comes to social movements. And so a later chapter of your book explains that there are acceptable forms of arguments in constitutional law because, spoiler alert to anyone who isn't a con law expert or lawyer, you can't employ the same kinds of arguments or rhetoric many of us are used to seeing in dramatized versions of court proceedings, or even very dramatic, realistic instances in which the Constitution is being invoked in political rhetoric. And so can you walk us through these different forms of arguments in the court setting and why they're important to understand as we discuss your book?
Yes, it's true. If you want to convince a judge that the Constitution means X or Y, you can't just say because X or Y would be a great idea or would help people. You have to use certain forms of argument that are recognized as legitimate in modern constitutional law. And those forms include appeals to the text of the document, the textualist arguments, appeals to what the framers who wrote and ratified the constitutional text understood themselves to be doing. Those are sometimes called originalist arguments. You can make arguments based on prior cases that the courts have decided. Those are arguments about precedent. And there are a few other so-called modalities of constitutional argument that are accepted by courts. What you can't do are some things that you might think would be totally inappropriate for a court to consider, like arguments based on pure emotion or partisanship. But you also can't make certain types of moral and policy arguments that matter greatly to regulators and ordinary people, and that might have been quite useful when it comes to drug prohibition. For example, most forms of cost-benefit analysis, when they look at punitive drug policies, find them to be totally unjustifiable. The amount of harm they do in terms of incarceration and corruption and crime that they breed, as compared to the good they do in stopping dangerous drug behaviors, is wildly lopsided. So you might want to say to a court, this is a cost-benefit disaster, this set of policies, but you can't do that and have it be counted as a constitutional argument. And likewise, you might want to say, this is a disaster from the perspective of liberalism or liberal theory. People should get to control their bodies, brains, homes. And you can't say that in a straightforward manner either in a constitutional case. So instead, you have to kind of work with the recognized forms of argument, try to weave in those kinds of considerations as you can, but it makes it harder to just offer the strongest case against the war on drugs that could have been made. Nonetheless, the book tries to show that in prior generations of American history, and very much so in the 1960s and 1970s, it was plausible that courts would strike down significant parts of drug prohibition on various constitutional grounds. So even though the norms of constitutional argument limit the ways in which you can attack drug policies, including some of the most forceful ways, it was still possible to develop credible attacks on their constitutionality. And we saw that again and again in hundreds of cases.
I want to give you a chance to talk about highlights of that history as you'd like to, but I particularly like framing the discussion so far as both an interest that you had in writing the book to kind of notice the dogs that aren't barking. I think that's a history that certainly somebody following today's drug policy conversation wouldn't be aware of, would be surprised to hear of, the range of successes and even some of the predictions of where constitutional arguments were going kind of around the time of obviously the 60s and the 70s was, sort of thought of as both a robust moment for drug use, whether we're talking about the hippies or an early psychedelics era, and then also the kind of the cusp of the war on drugs. And so love to hear kind of where your research and the book talks through the constitutional history that's also emerging at that time.
I think even among constitutional law scholars, a lot of this history is unfamiliar. And a lot of it was unfamiliar to me when I started researching the book. I knew enough to be intrigued, but learned so much more. What I think will surprise, I hope will surprise a lot of readers, is that much more recently into the modern era of constitutional law, the 1960s and 1970s, arguments for drug rights were back on the table, and they took a new form. Instead of being about limits on government's regulatory authority, Now they were about individual and group rights in the 1960s and 70s. And so people made claims based on liberty and privacy, racial equality, the rationality of government decision-making, arguments that certain drug policies amounted to cruel and unusual punishment. And all of this was happening in a cultural context, as you say, when drugs had exploded into the national consciousness because of the hippies and other movements. Just to say that things were surprisingly open. Constitutional law was undergoing a kind of rights revolution. The culture around drugs was quite complicated. You have, on the one hand, some reactionary forces building a generational divide that's reacting very negatively to the hippies and the youth drug culture. On the other hand, you have all kinds of government commissions and the American Bar Association and the American Medical Association and the National Council of Churches and the National Council on Rabbis all weighing in favor of drug decriminalization. So it was a moment of possibility that I'm trying to recover in the book.
One of my favorite little factoids relative to prohibition was that the 18th Amendment didn't seek to prohibit alcohol possession or use. It just focused on transportation, sale, manufacturing, and the like. And I do think in some ways it's an interesting echo, a century later, where our policy discourse has seemed to gravitated over time to we shouldn't punish the users. But is it your sense that as the conversations were developing in the 60s and the 70s as a constitutional matter, that distinction was in play? Was the kind of rights discourse mostly about kind of the right to possess and use rather than the right to sell or some other kind of transactional elements to it?
It's often forgotten about alcohol prohibition that in a sense it could be considered a form of decriminalization. In the 1960s and 70s, when we're talking about drug rights, it was almost always tied to use and possession. It varied by area, but people made arguments about how it intruded on their liberty or privacy not to be able to possess and use small amounts of certain drugs in the home or otherwise for themselves.
Can you talk us through maybe the instances where district courts or trial level judges were more moved by a range of the constitutional arguments, but appellate courts were not? Because I know that in your book, it seemed like the first instance you would have judges being like, yeah, no, these arguments make a lot of sense, but then their decisions were overturned by the next level.
It's true. A lot of the most interesting and pro-drug rights, if you will, decisions were issued by trial courts throughout this period, some of which then get overturned by the appeals courts. I think some of the insanity of our drug policy in this period was more apparent to trial judges than it seemed to be to the higher level judges. The trial judges are seeing these drug defendants week after week, and the volume of cases is going up and up, and these people are sympathetic figures who are getting hit with extraordinarily harsh sentences. When you move up to the appellate level, it's more abstract. The record is already finished. You're not collecting more facts. And it seems to lead to a more arid style of judging that perhaps was insensitive to the human cost of some of these punitive policies. Let me give an example. A lot of litigation centered on marijuana. And a lot of defendants argued that it was so irrational to put marijuana up there with the most dangerous drugs, often classifying it as a narcotic, even though it's not pharmacologically a narcotic, that it violates the constitutional guarantee of equal protection, which the courts had said requires classifications that are made in criminal laws to be at least minimally rational. So these defendants come in and say, this is fundamentally illogical to say that marijuana is a narcotic or as dangerous as a narcotic. And you have a bunch of trial courts, I found about a dozen of them, that said, you're right, that we have reached the point of irrationality. And these courts review the medical literature on marijuana in great depth. And they had expert witnesses testifying, and they find that these policies were just unsupportable. And then you move up to the appellate level, and those judges are not interested, basically, in looking very closely at a complex body of evidence around exactly which policies and which drugs are more or less rational. And they want to shut that all down, and they do.
Often Nixon is portrayed as the boogeyman starting the war on drugs in the early 70s. But I know there's a particularly rich story about how the Schaefer Commission, let's talk about that a little bit, kind of engaged with marijuana issues at kind of the start of this era. And, curious both how that fits into the social political history of marijuana policy, and then also, whether you think that report influenced courts or was, an important part of the constitutional dialogue at the time.
Nixon is a somewhat more complicated character in some areas of drug policy than the conventional wisdom might suggest. For example, he was quite careful not to demonize drug addiction or addicts, at least in his first term as president. Drug addiction was heavily associated with the Vietnam War. and the plight of veterans. Marijuana, however, he seemed to fixate on and associate with countercultural and kind of racial justice forces that he was opposed to. And so there he is more of a reactionary. Congress creates this commission to study the problem of drugs and drug abuse, and they devote their whole first report to marijuana. And when Congress creates the big new federal drug law, the Controlled Substances Act, scheduling all illicit drugs in 1970, marijuana is initially put in the harshest schedule, the most restrictive schedule, Schedule 1, but it's understood to be temporary. Until the Schaefer Commission could complete its study, it would start there, but then the idea was that they would look at the evidence and then readjust as necessary. So Nixon appoints 9 of the 13 members of this commission. It's not a liberal group. He stacks it with a lot of conservative allies. And nonetheless, they surprise him when in 1972, they come out with their big report and urge decriminalization of marijuana, say it's not a significant public health problem, and the evidence just isn't there to support the punitive policies that have been in place. And Nixon ignores their recommendation and is outraged by it, and Congress does the same. I do think that the Schaefer Commission influences the judicial debates that come in the remainder of the 1970s. And it's not just the Schaefer Commission. There are numerous government bodies in the United States and abroad, and numerous expert non-governmental bodies that are issuing report after report saying that marijuana is just not that dangerous and supporting some version of decriminalization. So the fact that all of these expert commissions weigh in favor of decriminalization, I do think helps embolden a lot of judges to be supportive of the constitutional claims they're hearing. Not only that, some of the judges explicitly cite these reports like the Schaefer Commission to defend what they're doing.
I've taught a marijuana law course for years now and assigned students parts of that report, obviously the parts that focus primarily on sort of the policy arguments around the public health issues and concerns and debates over different legal structures. And yet only recently did I discover, in part because it's not even available online many places, that they had like an addendum that included some of the constitutional arguments. And when you read that section, as I recall, it's almost in the spirit of like, it's only a matter of time before the courts start saying there are some rights here for people to use marijuana. So let's amend the laws so we get ahead of that rather than wait for the courts to tell us what to do.
So the court recognizes in 1965 a right to privacy for the first time, in this case, Griswold versus Connecticut. That's about the right of married couples to use and purchase contraceptions, not about drugs. But the legal community quickly realizes that this right of privacy might extend to the personal possession and use of at least soft drugs like marijuana, at least in the home. And so building on cases like Griswold and then Roe versus Wade and other privacy cases that come afterwards, you get all of these legal authorities saying, as you suggest, it looks like drug rights may be coming next. Let's take that seriously. And so the Schaefer Commission, in this little notice part of its report, says that, I'll quote, the analytical tools for a right of privacy being extended to marijuana are now available in cases like Griswold, and it cites a few others. And then it goes on to say that application of the criminal law to private possession of marijuana is constitutionally suspect under the existing case law. And the retired Supreme Court Justice Tom Clark, that same year, 1972, gives a speech in which he says that he predicts that the Supreme Court, I'll quote, might find it difficult to uphold the prosecution for possession of marijuana. 2 years later, 1974, a committee from the California Senate issues its own report saying that it clearly, I love that, clearly seems to follow from Roe versus Wade, protecting abortion rights, that there's a right to possess marijuana as well. So all of these people are drawing the inference from the right to privacy cases that drugs are going to be protected too. And not only that, a lot of leading academics and other lawyers said, if we don't recognize some either constitutional rights to drug possession and use, or the legislatures don't revise the laws to allow for it, the legal system is going to collapse. Millions of otherwise law-abiding Americans are going to be turned into criminals from all strata of society. And this is going to be unsustainable. And it's going to breed a profound disrespect for the law among the youth of the country. And so you have these new constitutional rulings enabling new sorts of arguments. And you have this recognition that the status quo is becoming unsupportable as we're creating a society of millions upon millions of drug criminals.
But instead of reforming policies so that that didn't happen, we seem to just accommodate that influx of individuals. What happened? Why do you think that there were so many people that still were processed through the system and it didn't break down?
I think basically, instead of the system collapsing because people couldn't handle criminalization on that kind of a scale, instead we got mass incarceration, which starts to take off, of course, in the 1970s, paired with a kind of racialized economy of who's actually getting punished that, to our shame, leads to elites, particularly white elites who are college educated, basically being spared criminal punishment for their non-trafficking drug behaviors, and then everyone else being subject to a draconian system.
I want to lean into that race story a little bit, particularly vis-a-vis concerns about unequal application of our drug laws. Michelle Alexander's The New Jim Crow perhaps being the kind of high watermark of popular attention to the notion that the drug war is about racial subjugation to some degree. Were courts attuned to and were arguments being made in kind of equal protection ways?
Actually, it's one of the puzzles that I found in my research, how few racial equality claims were brought until the late 1980s. Then they come to the fore when crack cocaine is punished so much more harshly, 100 times more by weight than powder cocaine. And crack cocaine was associated with Black inner city communities and powder cocaine more with wealthier white suburban communities. And everyone is aware of that racial valence. And then the enforcement patterns of those laws are wildly racially disproportionate. What's interesting is that in the 1960s and 70s, the equal protection doctrine on racial equality was much better for defendants claiming that such practices were unconstitutional. You did not need to prove at that time necessarily that there was an invidious discriminatory intent. If you could just show that there was a significantly different impact of a policy across racial groups, that could be enough to win. And yet, no one brought racial equality claims in the 1960s and 70s in drug cases, very, very few. It was known that these laws were passed significantly for racist reasons back in the 1960s and 70s. It wasn't like that's a recent discovery. The best known article on the history of marijuana regulation, published in 1970, for example, had dozens and dozens of pages of analysis of the racist history of marijuana prohibition. So where were the lawsuits? And I think it's some combination of the fact that the main drugs that were at issue in the litigation in the 60s and 70s were marijuana and cocaine. And at that time, they were increasingly getting coded as white on account of hippies and the collegiate counterculture and patterns of drug use at the time. In addition, the Black community, as we now know from a lot of great scholarship, was itself internally fractured over what to do about drug policy in this period, with some strong law and order voices urging harsher policies, not more lenient ones. And then systematic collection on patterns of drug enforcement by race hadn't really developed in earnest at that time. That would come shortly thereafter. So it was harder just to prove statistically that enforcement patterns were so racist. And then finally, the leading groups that were litigating these cases were groups like the ACLU and NORML, the National Organization for the Reform of Marijuana Laws. And I think they made a strategic decision as well to focus on privacy claims and liberty claims that didn't have an obvious racial tenor to them, on the theory that they would be more convincing to an overwhelmingly white judiciary. So for whatever combination of those reasons and possibly others, I see it as a big missed opportunity.
Is it possible that the civil rights movements of the 60s going into the 70s didn't like or would be potentially at risk if we're undermining government authority to kind of remedy problems, right? That, the civil rights acts of the era are about giving the federal government authority to come into the states and try to fix things, and that a line of arguments built around preventing the government from claiming to fix things for good reasons could itself kind of undergird a hesitation.
I think it's definitely in the picture that there's a concern that if you undercut the government's ability to go after drugs, you're going to unravel the whole regulatory and social welfare state, which liberals and progressives had worked so hard to build. I would take it back further than the Civil Rights Revolution to the New Deal era. Liberals and progressives defend various judicial doctrines that are all meant to enable the government to regulate forcefully on public health problems, public welfare issues. And one of the difficulties that the war on drugs presented to these courts and these liberal and progressives was that here we have a policy ostensibly done in the name of public health and public safety, which the whole doctrinal architecture was designed to allow the government to try to promote. And yet it's a profound failure on those very terms. It is undermining public health rather than advancing public health. And it's self-criminogenic. It is creating crime rather than stopping crime and protecting communities. And yet the judges are at a loss with what to do with a policy failure of that scale. And so I think that that's definitely in the background of all these specific disputes over specific clauses of the Constitution is this larger tectonic, issue of the whole structure of modern constitutional law was meant to allow for an aggressive regulatory state, and therefore it had a hard time dealing with a regulatory regime that was itself so destructive and failing even at its own ostensible purposes. If I might just go back for a moment to you referenced The New Jim Crow by Michelle Alexander. That book has some excellent discussion of one set of constitutional issues relating to the war on drugs. And this is the one set of issues that constitutional scholars have written about at great length when it comes to drug policy, and that's enforcement. There's a big literature on all of the intrusive police tactics used to go after suspected drug criminals. Stop and frisk, racial profiling, surveillance, and so forth. And a lot of those tactics have been challenged under the Fourth Amendment and its prohibition on unreasonable searches and seizures. And that's obviously a very important set of issues and a very important literature. What I'm trying to do in this book is say, before we get to the enforcement of these laws, the first order question is whether the laws themselves are constitutional. Can the government just prohibit you from using certain substances? Can it attach severe criminal punishment to those policies? And I think we've almost forgotten that that's where the debate was 50 years ago, not on the downstream issue of once those laws are on the books, how exactly can they be enforced, but can they be on the books at all?
And I'm wondering if you think that the reality that we still have enforcement debates and we have litigation over criminal prosecutions and investigations, do you think that might itself skew how courts look at a lot of these issues, that they're necessarily confronting drugs in very criminogenic settings rather than looking at that first basic question of, should an individual just be able to use drugs if they can do so safely and without government interference?
That's definitely possible. I think also it just normalizes aggressive, intrusive police tactics that no one is even suggesting that the policies they're enforcing are themselves constitutionally problematic.
In a previous episode, we discussed with Jack Chin and Rick Simmons how a ridiculous percentage of federal wiretap requests were just for drug activity monitoring. Most of these investigation tactics are around the enforcement of drug prohibition. But now I know that as states are legalizing, some of those enforcement tactics are coming into conflict with legalization provisions.
Certainly a bunch of states in the wake of marijuana legalization, whether medical or fully rec, have sought to sort through what does probable cause mean in a world in which now some marijuana use is allowed. And of course, the smell of marijuana, somewhat distinct from the smell of alcohol or other possible drugs, has always been an investigative technique that enabled law enforcement to have more access. I'm reminded now, you mentioned wiretapping, alcohol prohibition got us the Olmstead case, one of the Supreme Court's first encounters with these issues that also brought up these privacy issues and led to Justice Brandeis, rightly sort of reminding all of us that these are very personal realities that if we enable government to investigate and interfere are going to extend beyond just drug use and drug activity.
I've dug up one quote from the Schaefer Commission report on how if you have criminal drug prohibition, you're going to get very disturbing police tactics that follow. Here's the Schaefer Commission, 1972. Possession of marijuana is generally a private behavior. In order to find it, the police many times must operate on the edge of constitutional limitations. Arrests without probable cause, illegal searches, and selective enforcement occur often enough to arouse concern about the integrity of the criminal process. End quote. And for a lot of observers at that time, the consequence was, or the implication was, don't simply try to manage that terrible problem of over-aggressive police enforcement. Stop it at the root by limiting the ability to criminally ban certain drugs in the first place.
I know there's one state Supreme Court case that sort of stands out in this era, I think out of Alaska, that kind of highlighted a different path that is still good law. And I particularly want to hear about that in conjunction with whether the U.S. is par for the course around the world in kind of ignoring in modern terms some of these constitutional type claims, or if we're seeing different patterns play out internationally.
There were a number of state Supreme Court cases, not just trial courts, that issued celebrated opinions in the 1970s on different drug rights issues that I think hold up pretty well, actually, over the decades. And the most famous of them all is this case out of Alaska, as you say, called Raven versus State, where the Alaska Supreme Court unanimously held that under Alaskans' right to privacy, recognized both under the federal constitution and cases like Griswold, and under a provision of the Alaska Constitution on privacy, adults could possess small amounts of marijuana and use it in the home. And this was a kind of full-throated articulation of the privacy case for drug rights. And that kind of balancing analysis, Doug, is taken off around the world. And constitutional scholars refer to this as proportionality review, where constitutional courts, basically every other country except for the US, balance the liberty or dignity or privacy or equality interests that the plaintiffs bring forward against the government's regulatory interest in whatever policy is being challenged, see whether the policy is really justified. And using that kind of balancing method, courts across Latin America in particular, and now Europe, even parts of Asia and Africa, which have been slower to drug liberalization, have been increasingly finding that total criminal bans on marijuana are impermissible. And in every case, the analysis looks pretty similar, which is we're not necessarily saying that you have some extra special fundamental right to use drugs, but the governmental case for prohibition is just too weak. And they're willing to kind of acknowledge the failures of prohibition. The Raven case out of Alaska turns out to be this country's greatest drug law export because a lot of these cases around the world favorably citing Raven as a model for the right way to think about drug rights.
This balancing approach was far more common in American constitutional doctrine some decades ago. And now I think it's fair to say that we're seeing what might be deemed an originalist turn in the way in which our current Supreme Court approaches a range of questions. My sense from your book is that doesn't necessarily mean the end of all possible constitutional discourse on these issues. And so I'd love to hear you just talk a little bit about, whether and how you'd see an originalist focus on some of these topics might actually enable some reconsideration of these issues at a constitutional level in the U.S.
First, let me just try to clarify the comment on balancing and then take on originalism. So what I should probably step back and explain is that if you have a constitutional claim about a liberty or privacy interest that you think has been violated, what you now need to do under modern constitutional law is first convince the court that you have a fundamental right, a fundamental liberty or privacy interest that's been abridged. Only if you convince the court that you've had a fundamental deprivation of liberty can you get meaningful review and possibly win with your claim. So everything depends on that threshold showing of whether you have a fundamental liberty interest at stake. And that has proven an insurmountable barrier for drug defendants. They cannot convince courts that smoking pot or using whatever other illicit drug is a fundamental liberty. But that was not so clear in the 1960s and 70s that you would have to show that fundamentality to get meaningful review. Cases like Raven out of Alaska said, you just have to show us that there's some non-trivial liberty or privacy interest at stake here, which there is. And then we're going to assess the government's case for criminal prohibition on the other side. And that's really, I think, the structure of the best constitutional argument against draconian drug penalties when it comes to liberty and privacy is not that you have some super special liberty interest in drugs necessarily, but you have a meaningful liberty interest and the government may have a weak case for criminal bans. Now, this kind of rigid approach to liberty analysis that courts do is making it almost impossible to win your liberty and privacy claims here, unlike the rest of the world. What has risen in the place of kind of old school living constitutionalism is a much greater interest in originalism among the current Supreme Court justices. They want to ask, what was the original public meaning of a provision of the Constitution at the time it was drafted and ratified? And we're stuck with that. And that's the way to do constitutional interpretation. And you might think that's going to be fatal to drug rights claims, because certainly the framers of the Constitution, wouldn't have wanted to protect drug use. But in fact, there are numerous moves that originalists could make to attack draconian drug laws that, as a legal matter, are plausible. Politically, originalism is very associated with the conservative legal movement at this point, and so they may not be attractive politically to some of the judges, but I think they work. The Eighth Amendment prohibition on cruel and unusual punishment. What does that mean? Well, the best originalist scholarship on what that meant in 1791 when it was created was that it would prohibit not just barbaric modes of punishment, but also punishments that don't fit the crime, that are grossly excessive in light of the defendant's moral desert. And a lot of people have suggested that under that understanding of the cruel and unusual punishment clause, long prison sentences for nonviolent offenses like drug possession or use are unsustainable. And so it's a pretty straightforward, clean argument that the original understanding of cruel and unusual would block a lot of our harshest drug sentences. Other more controversial originalist argument would revive clauses like the Privileges or Immunities Clause of the 14th Amendment, which would allow people to make new kinds of liberty arguments that have been choked off under the Due Process Clause. Other originalist arguments say that the federal government has way less power to regulate drugs than the court has said, and so they would roll back congressional authority in ways that would be helpful for drug liberalization, but might undermine environmental and civil rights statutes and other laws all over the place. So a lot of these moves have tough trade-offs associated with them, and I'm not sure that a conservative judiciary is going to want to bite on all of them. But within the scholarship on originalism, one might be surprised by just how many ways you can leverage that scholarship to attack draconian drug laws. And again, the one I favor the most, and I think really would be the most straightforward to apply, is that judges need to do a much more serious job of policing harsh punishments if they're going to be faithful originalists and recognize that the framers wanted exactly that kind of close scrutiny of long sentences.
I know of a colleague who's written thoughtfully that an originalist approach to the Eighth Amendment means that the federal government can't punish much more harshly than state governments are doing. Basically, it's sort of its own sort of version of a federalist limit. And when we look at particularly marijuana, where the vast majority of states have legalized in some form or another, and the feds still have prohibited, there are, again, arguments that can be built out of there that not only am I excited that you're suggesting them, but I think it's an area where any constitutional litigator who wants to have a chance to develop claims in this space needs to at least be thinking about bolstering their other claims, because it's not just the Supreme Court, it's a number of other judges who've now kind of robustly embraced originalism as the way to approach these topics.
I don't think one needs constitutional law or litigation to attack punitive drug laws. There are plenty of good reasons outside of constitutional law to think that they're unwise and counterproductive. And that's where most of the reform energy has been. But this is an area, unlike some other fights for social justice or racial justice, where there's an enormous volume of criminal cases coming in week after week, hundreds of thousands in the last year alone. So judges are going to be resolving legal challenges to these drug policies and sentences, whether one appeals to their constitutional conscience or not. So under those conditions, when you have a massive volume of litigation that's going to be happening no matter what, then I think it really behooves legal reformers to use all the tools in their toolbox and to fight some of those prosecutions with constitutional law when they have plausible arguments. And I think that civil society groups and the defense bar and the legal academy have all lost touch with the fact that for most of American history, there were thought to be very credible constitutional arguments against harsh drug prohibitions. And reviving that anti-temperance tradition or the libertarian tradition or the whatever you want to call it in American constitutional culture and law could only help the broader reform efforts to achieve more humane and sensible drug policies.
We've legalized recreational marijuana in Ohio. What do we do with all of these convictions and charges that people have on their record from years and decades past? And so I understand it's not just the trial level, it's what happens after trial, but trial in and of itself doesn't often happen. It goes from you take a plea deal and you go to sentencing. And so while I hear these are really good constitutional arguments that you could take at trial, you have to go to trial. You have to take that risk because there are all of these other factors within our punitive system that make going to trial very risky and make taking a plea deal very attractive. And so when you are one of many being processed through the system, why should anyone take that risk?
You're putting your finger on a huge development that has facilitated mass incarceration and the collapse of constitutional law in this space, which is the eclipse of the jury trial by the plea bargains. If everyone got their trial, the system couldn't handle that caseload and would have to adjust. And so ideally, you might want to see defendants and their lawyers getting together and agreeing all to go to trial and putting that kind of pressure on the system to force reform. But it's not in the interest of any one defendant necessarily to do that, and they can't all coordinate to agree to do it together. Still, however, there can be test cases, and there's certainly legal groups that want to challenge drug policies, NGOs, that try to engineer just such cases, notwithstanding the decline of criminal jury trials. You don't need everyone to litigate the constitutional issues to have positive spillover effects on the whole system. If you just get a small number of defendants who are bringing these constitutional claims in a serious way and getting judges' attention, that would also change the dynamics of plea bargaining, because then defendants would realize, oh, okay, I actually have some constitutional moves I might make that judges might be receptive to, and they're either going to get better plea deals or be less willing to cut those deals in the first place.
There was a part of your book that was really interesting and almost energizing, where you talk about jury nullification.
There's a whole body of originalist scholarship that suggests the jury was meant to be the conscience of the community and to have the power to acquit, not just when it thought the facts didn't support a finding of guilt, but also when it disagreed with the law in question. It is often said that in the 1920s and the early 1930s, juries nullified quite a bit when it came to alcohol prohibition. They did not find those laws acceptable or wise, and it seemed they were unwilling to convict in many cases. And that pattern hastened the demise of alcohol prohibition. It helped show how much popular opposition there was, and is often credited with helping spur the movement to bring back booze. Some scholars have written, could we do the same when it comes to other drug policies? And if we just get some juries showing a willingness not to accept our harshest drug laws, that too would fundamentally change the dynamics, I think, around prosecutors charging and who's going to trial. That's another originalist move that I think is quite credible, that we would be open to some forms of jury nullification, even though there are certainly downside risks there too when it comes to punitive drug policies. Judges completely shut down pathways for nullification in earnest to the 1970s and started not even allowing the provision of information to jurors or prospective jurors about the possibility of nullification, and striking any member of the jury pool who shows even awareness of, much less attraction to, the idea of nullification.
What was fascinating to me teaching cannabis law for the last decade was there were all these parallels between young people's interest in support for same-sex marriage and young people's interest in support for cannabis reform. And then the paths diverged dramatically because the same-sex marriage conversation becomes a constitutional law conversation, whereas the cannabis reform discussion never has even made that turn.
The book makes clear that the argument that there's a right to same-sex marriage, say, or personal gun ownership for self-defense purposes was way further off the wall in the 1960s and 70s than the argument that you have a right to possession and use of drugs in your home. Of course, now it's flipped, and same-sex marriage and personal firearm ownership are recognized by the Supreme Court, as part of federal constitutional law, but they were more radical arguments legally at the time. The different fates of those rights movements is quite interesting and instructive, I think. And the book tries to analyze why they diverged. I think it's important to recognize that constitutional arguments could be made to bodies other than courts. And in particular, Congress and the administrative agencies like the Drug Enforcement Administration, they also have an independent obligation to respect constitutional rights above and beyond what the courts might be doing. Hannah started to bring up all the messy problems with reckoning with past drug injustices and misguided policies and cleaning up that mess, as well as developing new policies to support people with real drug problems, with abuse and addiction, and deal with something like the opioid crisis. Common law can't solve all that. The one thing that common law is well structured to do is to stop government overreach when it goes too far in the direction of restricting liberty and punishing. And that's what courts started to do in the 60s and 70s and stopped doing. The problem of developing good drug policies that will, support public health and communities going forward, common law can't solve, but it can at least start to unwind some of the worst excesses of the policies we've had for many decades.
Drugs on the Docket is a production of the Moritz College of Law Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.